How do mediation and arbitration differ in divorce? Imagine trying to settle a disagreement without going to court. That's what mediation and arbitration aim to do in divorce cases. Both are alternatives to traditional court battles, but they work quite differently. Let's explore how each process helps couples resolve disputes and what makes them unique. In mediation, a neutral person called a mediator helps the spouses talk through their issues. The mediator does not decide the case but guides the conversation so both sides can find common ground. The spouses keep control of the decisions and must agree voluntarily. Any agreement they reach is only binding if they both sign it. If they cannot agree, they can still go to court or choose arbitration later. Arbitration is more like a private court. An arbitrator listens to both sides, reviews evidence, and then makes a final decision. This decision is usually binding, meaning both spouses must follow it. Arbitration tends to be more formal, similar to a court trial, with legal arguments and sometimes legal representation. It is often used when couples want a quick, clear resolution and are willing to accept the arbitrator's ruling. Mediation is informal and flexible. It encourages open discussion and cooperation, which can help preserve relationships, especially when children are involved. It is usually faster and costs less because it does not involve formal court procedures. Arbitration, on the other hand, is more structured and can be more expensive because of the formal process and the arbitrator's role as a judge. Control over the outcome is a big difference. In mediation, the spouses decide on issues like child custody, property division, and support. They work together to reach an agreement that suits both. In arbitration, the arbitrator makes the decision for them, which can be helpful if the spouses cannot agree or need a quick resolution. Another key point is binding decisions. Mediation agreements are only binding if both spouses sign and agree to them. If they do not reach an agreement, they might still need to go to court or choose arbitration. Arbitration decisions are typically final and binding, with limited chances for appeal. Both processes are private, unlike court trials which are public. Mediation is usually less costly because it takes less time and involves fewer formalities. Arbitration can be more expensive due to its structured nature and the arbitrator's role. In many divorce cases, mediation is the first step, especially when spouses are willing to cooperate. If mediation fails or the issues are too complex, arbitration might be used to get a binding resolution. Sometimes, couples start with mediation and then move to arbitration if needed. Choosing between mediation and arbitration depends on how well the spouses can negotiate, how much control they want over the outcome, and how quickly they need a decision. Mediation supports working together and reaching mutual agreements. Arbitration provides a clear, binding decision when cooperation is difficult. Both options help couples avoid lengthy court battles and find a resolution that fits their needs.